Okay. Good morning. I'm having all sorts of problems this morning, you all. I apologize. From forgotten passwords to chair problems. All right. I'm going to call the calendar for the civil non-jury and check for announcements. For position 1, Capital One versus Jamisha Bailey.
Good morning, Judge. This is Lewis Feingold. And I have exciting news. This case is settled, and basically it's for a lump sum, and the payment is due like in a few more days. Is it possible to get a one-time reset so that when the check clears, we can file a dismissal?
Okay. Ms. Lawrence, what's the next calendar? Because all of my calendars have gotten up and walked away.
June 17th at 1:30.
June 17th?
Yes.
Okay. All right. Will that be enough time, Mr. Feingold?
That will be plenty of time, and I really appreciate that.
All right. So if that's everything, is anyone here on behalf of Ms. Bailey? Or you just
No,
announced
they
it for
called
them?
me last night, and so I'm making the announcement.
Okay. All right. Thank you, sir. You're excused.
All right, sorry you're having problems today. I hope it's going to straighten up and get better.
It will. It will. Thank you.
All right, see you later.
All right. All right. Position 2, LVNV funding versus Adrena Hemphill.
James Wooden here for the plaintiff. And
Olivia Harmon here for the defendant.
And we sent over to Ms. Harmon. She's got a consent judgment with which we've agreed to, and it just has to be executed and returned, and then we'll file it with the court.
Okay. And so how long do you anticipate that will take, Ms. Harmon?
In the next couple of days, I will get it signed and send it back over to Attorney Wheaton, and then he can file it with the court.
Okay. Shall I continue this to the next calendar just to keep up with it? And then once it's submitted, you all will be excused?
That would be fine.
That works. Yeah, that works for me.
Okay.
Yeah.
So this will also go on that June 17th, but once everything's submitted, you don't have to appear on this matter.
Thank you.
Okay.
Thank you.
Thank you, Olivia.
Yes, you're excused.
Thank you.
And the third matter I received notice was already dismissed, Crown Asset Management versus Shakia Pardue, and hopefully no one is present here for that. All right. I'll call the oral argument calendar now. First position, Scott Sheffield versus Ashante Thrasher, Shayna Bowyer, and I believe there is a State Farm.
Attorney Pouliard here on behalf. Plaintiff.
Okay, I'm sorry.
Attorney Pouliot here on behalf of defendant, Ms. Boyer,
Okay,
and also the filing, the move-in in this.
okay.
And I'm Attorney Moses Palin here for State Farm.
All right, and you say your name is Moses?
Yes, ma'am. Moises. I'm here in place of Attorney Lee.
Okay.
And
Thank
Your
you.
Honor, my name is Anna Dillon. I was with the plaintiff on the counterclaim. I'm just here observing today.
Okay. And there was someone else, I believe, was talking initially, and I couldn't hear what he said.
Is that me, Your Honor? I'm Barrett Kerbo. I'm here on behalf of Plaintiff Sheffield.
Okay, yes, that was you. All right, Mr. Kerbo, thank you. So Miss, is it Polliard?
Yes, that's correct.
How long do you anticipate your motion will take, your side at least?
Less than 30 minutes, Your Honor.
Okay, and Mr. Kerbo, your side?
10, 15 minutes at the most, Your Honor.
Okay, great. I'll be back with you all in just a moment. Thank you.
Okay.
Position 2, Rigoberto Cortez versus John Doe. Well, I'm sorry, that's been settled. Hopefully no one is here on that matter. Position 3, also excused Citibank versus Kiana Kendall. So hopefully no one is here on that. So you are the only case I have. So it don't matter how long it's gonna take. I'm yours. Did you wish to have this taken down, Ms. Polly?
I do not, but if opposing counsel so chooses, then I'll share.
Mr. Kerbo?
Your Honor, since it's 21 bucks a piece, yeah, I'm fine. Just go ahead and pay for the takedown just to have it since we're here.
Okay.
So I'll share.
My court reporter, Ms. Maynard, has her information up on the screen. Ms. Maynard, is there any other instructions you wish to give parties?
No, Judge, that's gonna be it.
Okay. So how did you want to, are they submitting payment to that particular email, or did you put something else in the instructions that I did not see?
We have the email for the Zelle and we have the link for the Cash App in there. So either way, it's up to you guys what you want to do there. But I have the Zelle and the Cash App link for you guys.
Is there a card? Way to pay via card?
I don't have the card set up, no ma'am.
Okay, I'll just contact my office to do the Zelle portion.
Okay, perfect. Thank you.
No
Mhm.
problem.
All right. I guess we'll go on the record at this point. This is the matter of Scott Sheffield versus Ashanti Thrasher, Shayna Boyer,
Boyer.
thank you.
Mhm.
With State Farm Mutual as the UM. Case number 2026 CV 00275. This is the defendant Boyer's motion for summary judgment. Miss Vicky Polliard is present on behalf of defendant Boyer, and the plaintiff is represented by Mr. Barrett Kerbo, who is present. Also present is Miss Anna Dillon, I believe, who is representing the plaintiff on a counterclaim. Is that right?
That's correct.
All right. And Mr. Moses Patlin is present on behalf of the State Farm. Ms. Polliard, you may proceed with your motion.
Yes, Your Honor. I mean, ultimately, this situation is quite straightforward. It's our position that it's quite straightforward. There was an accident that occurred on January 22nd, 2024, between the plaintiff and defendant Ashanti Thrasher. Let's see, on January 31st, 2024, the defendant, Shauna Boyer, who is the mother of Ashanti Thrasher. In addition with Ashanti Thrasher and the plaintiff came to an agreement that $4,000 would be paid to the plaintiff. He executed what is essentially a general release of liability, and everything was thought to be done. Almost 2 years, to the date with respect to the statute of limitations, there's a filing, my client is served. Now, with respect to the accident within itself, the police report reflects that Miss Thrasher, it was the driver. Miss Thrasher was not insured at the time. Miss Thrasher is the owner of the vehicle. In the plaintiff's petition or complaint, there are claims and allegations that Ms. Boyer negligently allowed Ms. Thrasher to operate a vehicle and just added additional issues of negligence as it pertains to her. However, our position is there is no negligence as there was no duty on the part of Ms. Boyer. She is simply the defendant Thrasher's mother. She has no legal connection to her as it pertains to any insurances. The vehicle, there's nothing that attaches Miss Boyer to Ashanti Thrasher's vehicle, her driving, anything of the sort. And to be clear, Miss Thrasher was an adult at the time of the accident. The only connection it seems that they are trying to hold on to is the fact that she helped in paying the $4,000 in which Mr. Sheffield signed off on with a notary. Now, as the court knows, I'm actually here in person, didn't realize this was on Zoom. And for whatever reason, my computer's not logging on to the Wi-Fi. So I wanted to, it's kind of difficult for me to submit the police report in addition to the agreement. But
Let me
at
give
least
you the private Wi-Fi. And I thought you may have some issues. I was hoping it was working correctly.
I had the private Wi-Fi. For whatever reason, the computer no longer can pick it up. So when I was in
Oh,
the courtroom, it was there. My iPad lets me do the private Wi-Fi, but it is not picking up, not the private, not the public, nothing is picking up for some reason with the
in that
Wi-Fi.
room, in that
Yeah,
conference room.
nothing is picking up.
Okay.
But I think even still, without it, Your Honor, it's just the simple fact that, again, for there to be an issue of negligence, there has to be a duty, there has to be a breach of duty, there has to be damages. At the end of the day, Ms. Boyer has zero duty in this situation. I understand in the response, the plaintiff had stated that, well, we provided no documentation that she didn't have duty. Well, if she doesn't own a vehicle, how can she provide you documentation that she doesn't own a vehicle? Only the vehicle owner can provide that to you. Same with the insurance. The vehicle owner or the driver can provide that insurance information to you. There is no connection but for making that payment. And making that payment alone does not create, a backdated duty as it pertains to Mr. Sheffield. I mean, quite frankly, with respect to that, he signed the release days after the accident. In doing so, it's not as if it was the same day. It shouldn't be an issue of duress, shouldn't be an issue of, him being forced into making this or executing this document. If there had been concerns with respect to her being Miss Thrasher's lack of insurance, then he would have contacted his uninsured motorist directly. And as I understand it, in doing so, there was a denial because of this general release. And we say general release because, again, for it to be a limited release, there would have to be specific languages. However, in this situation, it was just simply a matter of, I've received this $4,000. There's nothing more that is needed from Ms. Thrasher. And only because Ms. Boyer signed off on it, since she gave her daughter, the money to be able to pay it, our position is that there was a benefit of the bargain. He knew what he bargained for, and he's received the benefit of it. I mean, at the end of the day, Miss Boyer at least has zero just zero reason to be part of this case. There's nothing that attaches her to any sort of duty, any sort of liability with respect to this case. And for that reason, there should be summary judgment as it pertains to her, and she should be removed as a defendant.
You said that she signed off on the release.
There was a release where he was paid $4,000, stating that, it's for the accident, nothing more is to be owed. And she signed it with Mr. Sheffield.
She
But
mean Ms. Boyer.
Ms. Boyer signed it, yes, with Mr. Sheffield. But in doing so, as I stated, this is something that was after the fact. So when you're looking at the accident, when it occurred, there is still no duty. It's almost akin to if an insurance company signs off and sends you a release for the accident and they made the payment. We're not saying that the insurance company was liable for the accident. They're providing the funds to settle the case. And so in this situation, Ms. Boyer provided the funds to settle the case, but at no point in time was she accepting liability. And the liability can't even be transferred in this type of way because she, again, wasn't the driver, does not own the vehicle, does not insure the vehicle, was not present during the time of the accident. And Ms. Thrasher does not, actually, they don't even live with each other. And Ms. Thrasher is an adult.
Okay. Anything else?
No, other than, again, with respect to the police report, it very clearly states that who the owner of the vehicle is, the insurance or lack thereof at the time, and that it is clear or should have been clear to the plaintiff that Ms. Boyer has no connection to the accident itself.
All right. Thank you. Mr. Kerber.
Right, Your Honor. So I want to start out. There were several documents that were referenced by opposing counsel. The main ones I heard were a release or a contract, and also the police report. Before we get anywhere, I first want to object to any, if they try to introduce those later at any time, I'd like to go and object to that introduction. This is a motion for summary judgment, Your Honor. So by the rules, the moving party, when they want to use an affidavit, when they want to use a deposition, when they want to use any documents to support their motion, they have to file those documents with the court on the day they file the motion. And if they somehow forget to do that, then they can, in some circumstances, do it on a different day, but it still has to be within outside the 30-day period before the oral argument hearing is scheduled. So those documents have never been filed. They were not filed with a motion. They were not disclosed. They have not been produced to opposing counsel, to myself. They've never even been made into the record. We sent them discovery. They did not produce any documents, basically saying they weren't going to produce any documents because of this pending motion. So no documents have been produced by opposing counsel or have been put in the record for this motion. So the only thing that the court can consider is basically their bare motion and obviously the pleadings in the case. So that's where I want to start, is based on the law, they have not done so, introduce any type of documents timely. So the only thing that we're here to talk about today is our bare brief writing. So their motion, their brief in support, and then my response brief. There's been no documents or information filed with the court whatsoever. Okay.
Okay. Have you filed anything?
No, Your Honor. No. So basically the only thing that can appear in front of the court is my complaint and their answer of our complaint, Your Honor.
Okay.
So, and that's really what my motion was about, Your Honor, is in motion for summary judgment, the moving party has the burden, right? So they are asking the court to grant their motion. So they have the affirmative duty to go ahead and present evidence to pierce the plaintiff's complaint, right? So when I file a complaint, those complaints are allegations, okay? And the whole purpose of this is we have to prove our allegations. So when they file a motion for summary judgment, they have to present evidence to basically pierce my complaint. When they fail to do so, what the court can do is they look at the complaint, they look at the answer, and then basically, if that's all there is, then the court has basically must look at the two and treat them as true, right? So because my allegations haven't been rebutted or pierced, and I haven't proven their denials are not true, right? It's a stalemate at that point. So when all we have is the complaint, when all we have is the answer, then it's a jury issue. And so until they are able to actually to present
On
evidence,
issues of law, Mr. Kerbo?
I'm sorry.
On issues of law, like a duty?
Well, or anything, yeah, it would be considered a factual dispute that a jury would weigh. I mean, yeah, I mean, when I file a lawsuit, I lay out the conclusions. I lay out the duties that someone has. I lay out the facts to basically show how they breached their duty, and that's what I've done in my complaint. We allege that the defendant in this case was the owner of the vehicle. That has not been rebutted by opposing counsel. There's nothing in the record showing that she is not the owner of that vehicle. They could have produced a title. You know, I don't get titles pre-suit, so I file a lawsuit. You know, that's the whole point of filing a lawsuit and including different parties is because a lot of times we don't know what's going on until we file a lawsuit, right? So they have to prove she was not the owner of that vehicle, and they haven't done it. There's no title. She references a police report, but the police report can't be used by the court because it hasn't been submitted to the court. There's no discovery responses. There's no interrogatory responses explaining who's the vehicle. There's no photos. There's nothing. So when there's no evidence to basically establish their case, then, you know, it's basically just my word against theirs. It's my complaint against their answer. So, and that I don't have much more, Your Honor. I just want to, you know, when you file a motion for summary judgment, you are basically showing a small window into your case in front of the judge, right? I mean, when you file a motion for summary judgment, what you're basically saying is that I'm going to give you a little bit of our evidence, and that's all I need to show you that this case cannot go in front of a jury. That's all I'm showing you, just a little smidge of my case. I don't have to show you the entire case. I just need to show you the one issue where there's no genuine issue of material fact. And by showing that, and if the plaintiff can't rebut that evidence, then the case can't go in front of the jury. And so you have to establish that through either testimony, through documents, through evidence that you're going to present to a jury. If you don't have any evidence, then you can't win on motion for summary judgment. If all you can do is basically deny the fact that you didn't do something or that you're not the owner of something, then that's not good enough to pierce my complaint. So that's really all I have, Your Honor. It was a short brief. Our argument is that the documents that she discussed in her opening cannot be utilized, cannot be referenced. And because of that, there's really nothing to show that she's not the owner. You know, I should still be able to prove that she is the owner. No depositions have been taken. No affidavit's been issued. You know, I should have the opportunity to prove she is the owner.
Well, I guess I disagree with your understanding of the law, Mr. Kerbo, but and the reason I say that is because on issues, ultimately the plaintiff bears the burden of proving their case, right? At trial, she doesn't have to prove that she didn't own the vehicle. That's your burden to prove that she does own the vehicle. And so if she's contending, if the movement is contending that there is an essential element of the claim of negligence is missing, being the essential element here being duty, which is the legal component, that's the law. Well, obviously duty is different from causation, right? but duty is kind of something that needs to be established. It needs to be some evidence to establish what the duty should apply to the defendant that she breached. And so here, if they're pointing out, hey, there's no duty, I think that the non-movement, I think the law says that the non-movement has to establish something to say there's a jury issue that there is duty. Because in this case, what you're saying, there would be no reason to have, well, I won't say that. I won't go that far to say that. But there would be way more cases going to jury where there has been nobody presenting any evidence to even determine if it should get to a jury.
Let me ask you this, Your Honor. When you say she's presented something showing she's in, I want to make sure we're on the same
An
page.
argument, the contention that there is no duty.
Yeah. Okay, so what the complaint says is that she was the owner of the vehicle. And so therefore she's negligent for, it's called a negligent entrustment claim. We file it all the time, right? So we are alleging she had a duty to basically not negligently loan that vehicle to someone who's not
a good driver.
A good driver. Yeah. We anytime we ever get a case where we have an at-fault party and an owner that by someone who else who owns the vehicle, we always include the allegation. We include both parties. That's good practice. That's what we do in every case because we do win some of them. And so frankly, that would be our claim of negligence against her is she does have a duty under negligent trust not to negligently entrust her vehicle to someone else. So, I mean, that's the allegation. And they haven't presented any evidence to rebut that. I mean, all they've done is denied it in their answer. So, I mean, that's what I'm saying is if all they've done is denied it, then they have not met their burden as the moving party. So they have to somehow, they have the initial burden on summary judgment. Now, when we try the case, that's my burden to present my case. If I don't do it, I get out on direct verdict. But on motion for summary judgment, when they're the moving party, they have the initial burden to prove their defense. And then it shifts back to me to basically provide evidence to create that material issue of fact. And that's typically what I see on motion for summary judgment. Like I had a case last year where my lady, she was crossing the road and she was hit by a vehicle, right? We took depositions, we had affidavits. The defendant driver testified that he didn't do anything wrong, right? He wasn't speeding, he wasn't paying attention, he was driving, he wasn't drunk. And our lady, frankly, didn't really know what happened because she was hit, she was hurt real bad, and she really doesn't know what happened. And she testified to that. So that was a major issue because he was saying he didn't do anything wrong, and she really couldn't rebut that. But this was also under a deposition. So he testified, they provide documentation. When they filed their motion for summary judgment, it was all under sworn testimony. They had the police report submitted properly. Everything was done the right way. And so I had major issues. Luckily, I had a witness who supported my client, and we were able to at least create a jury issue that he was speeding. So the witness opined that he was speeding. So, I still may go get my butt whooped at trial, but we were able to establish that factual dispute, even though the driver basically denied everything. Here, Your Honor, they have not really tried to present their case at all. I mean, all they've done is denied it in the answer. So that's my argument, Your Honor, is that it's not that I may not lose in the future, because I don't know. They have not done what they're supposed to get the case ready for a motion for summary judgment, right? So they've got to somehow prove their argument, and then the burden shifts to me. So once my complaint is pierced, just like in the case I cite in my brief, that's when the duty shifts to me. But the initial burden is on the moving party, which is the defendant in this case. And this is just for purposes of summary judgment, not for trial.
Okay, thank you.
Yes, Your Honor.
Ms. Polliard, closing on your motion.
Yes, with respect to the adding of the police report and the signed documents, which I agree. It looks like we missed having that added to the motion itself, though it's not to say that it's not within the hands of opposing counsel. Our position is that, again, to say that, well, we didn't present the title It is not her title to present. I cannot give you what I do not own. The defendant cannot give you what she does not own. And so that is something that would have to be obtained through Ms. Thrasher. And at this point in time, we do not represent Ms. Thrasher in this case. And
What about an
so,
affidavit from your client? Isn't that evidence?
well, within evidence, we did in I believe it is the request for admissions, we responded to the request for admissions where we did in fact state that it was, we denied any allegations of her owning the vehicle, negligently allowing her daughter to drive the vehicle. And in our counterclaim, we even specified that she is not the owner of the vehicle and she did not negligently allow her daughter to drive the vehicle. So within the request for admissions and within our counterclaim, we make it very clear that she is not the party to, she's not a party to this case, or she should not be a party to this case.
And
And
I'm sorry, I had a question. So are those responses to the discovery that you mentioned that your client completed, are those able to be considered on summary judgment if they have not been um, attached as exhibit to your motion? Or
I do not
can they
believe.
be considered because they're part of the record? Well, I don't have them. They weren't filed. So yeah,
Because I believe in this situation, we don't typically file the discovery responses. We just file the Rule 5.2.
so I can't
Then
consider.
there, yes. And so I guess one of the only other things I can ask, Your Honor, is if this matter can be continued with respect to allowing us to attach the necessary documents. And in this way, it can prevent, further having to go in, further drafting, further documentation for something that can be put to rest relatively quickly. And so one of the things I would ask again is if Your Honor would consider a 30-day continuance, we can amend our petition to attach the police report and the release that were signed by the plaintiff and defendant, which counsel would have a copy of, should have a copy of, and be able to return within 30 days.
Mr. Kerbo,
Your
what
Honor,
is
I
your
could,
position?
I can send you two cases, and also just copies of 9/11/56 and 9/11/6. I mean, and basically where those rules are construed together is, like I referred to earlier, if the moving party doesn't bring evidence with them when they file the motion, or at a minimum within 30 days of the hearing, unless they've gotten a previous court order or stipulation with me, those documents just can't be used. I mean, I think it's reversible error if they're used. So my argument would be they cannot be utilized for this purpose. A continuance would not solve that issue. And that's my position. Is you've got to follow procedure, and if you don't utilize the documents when you have them, you can't use them today at oral arguments, because this is not an evidentiary hearing. This is an oral argument based on what's supposed to be the evidence that was already submitted before this was scheduled.
But if this was to be continued and we have the 30-day window and they're submitted, then they would in fact be within said window, within your possession, and the filing of the court.
Your Honor, the oral argument was already scheduled. It's happening right now. I would stick to my position.
Okay, well, if I deny this motion, then I don't think there's anything that prevents the defense from refiling it. So, I mean, if the evidence is there for this to establish duty, then we need to, to create a jury issue as to the element of duty. Then that is something that, of course, needs to be done before we bring in jurors to consider these issues. So I won't grant the continuance at this point, Ms. Polliard, but my position on this, I will rule on this based on the evidence and the arguments that have been presented to me and the law. I will certainly consider both positions and my own preconceived notion of what the law is and make sure that that's correct before I rule on this motion. Was there anything else, Ms. Pollard, that you wanted to state in closing on your motion?
No, Your Honor.
All right. Ms. Dillon or Mr. Patlin, is it anything that did you all need to put anything on the record, any arguments or positions?
No, Your Honor.
Nothing for me as well, Your Honor. Thank you.
All right, that will conclude this matter. I will leave this Zoom up a little longer in case the court reporter needs to speak to either of you, any of you. Thank you. Have a good rest of your day.
Thank you, Your Honor.
Madam Court Reporter, I think you stated the information can be found. Where was that again?
Okay, so the information is in the chat box, and you
Okay,
will see the Cash App information, and you will see the Zoom information in there. It's my email for the Zelle, or not Zoom, I'm sorry, Zelle information. You'll see my email for the Zelle, and you'll see my link for the Cash App, or my contact for the Cash App.
well, you know what? When I switched devices, it did not keep the messages.
Are you here? You're in the building, aren't you?
Oh, yeah, I am.
Okay, I could just connect with you in person and give you the information. That's fine.
Okay, that works. Thank you.
And
No problem.
I have a question too. So I've never used Zelle or Cash App. I'm always been a Venmo guy. How do I, and I don't have an account. How do I do Zelle? Can I just like go to Zelle and type in your information and pay it? Or do I need to set up my own account or?
You can just do it through your banking app. Most banking apps just have Zelle like integrated into the app on your phone.
Correct.
That's correct.
So when you say, okay.
If you go to your bank and you look at like, I think transfers or pay or
Yeah.
send money, depending on who your banking institution is, it will direct you to the ability to use Zelle.
So just use that email account and that's all we need.
Yeah.
Well, I will do that today. All right. Thank y'all.
Thank you.